Hello, everyone. Welcome to the Death Penalty Focus webinar on how the death penalty protects no one. We're holding this webinar in honor of World Coalition Against the Death Penalty World Day, which is Wednesday. I think it's Wednesday. Yes, Wednesday. And we have a really wonderful panel that we're very excited to present to you. And we will present to you. I am here with Yoko Otani-Sperlin, my co-worker, who is running things behind the scenes. And I am here also with Death Penalty Board member, Dr. Philip Hansten, who is going to moderate the panel. So Phil, I'm going to turn it over to you to introduce our panelists and take over. Thank you very much.
Great. Thank you very much. And thank you, Mary Kate and Yoko, for doing all of this, setting it all up. And welcome, everyone. A quick heads up before we actually start. I had some dental surgery last week, and I have some hardware in my mouth that my tongue hasn't gotten used to yet. So if I slur anything, I haven't been drinking. I want to assure you of that. So as most of you know, World Day Against the Death Penalty is this Thursday, and Death Penalty Focus is marking the 22nd World's Day theme that the death penalty protects no one, with a discussion with three people who can attest to the truth of that statement, as well as, if not better, than anyone. I want to welcome our panelists, Shelan Joseph, Special Counsel to Los Angeles District Attorney George Gascon, Miriam Aroni Krinsky, a former prosecutor, national advocate, and policy reform leader who served as the founder and executive director of Fair and Just Prosecution, and Stephen Oliphant, a postdoctoral research fellow at the University of Michigan Institute for Firearm Injury Prevention, and whose study on the death penalty moratoriums appeared recently in Criminology and Public Policy. Thank you all for being here. I know how busy you all are, so we really appreciate your participating today. Stephen, I'd like to start with you. And Shelan and Miriam, please feel free to weigh in after Stephen's done if you want to add anything. And the same goes for you, Stephen, when they're talking. Stephen, in your paper titled Estimating the Effect of Death Penalty Moratoriums on Homicide Rates Using the Synthetic Control Method, you talked about the role deterrence has played in the justification for the very existence of the death penalty. Could you elaborate on that?
Yeah, and thanks for having me, Phil. So two of the main justifications that we often hear made for the death penalty are like retribution or just deserts for severe crimes, and the second being deterrence. Of course, there are other justifications, but those are kind of the two main ones. And with deterrence, the theory is that a punishment like execution is so severe that it would discourage people from committing homicide. Of course, there are a lot of assumptions that must be made to make that argument, including the notion that potential perpetrators are acting rationally in weighing the costs of their actions and the likelihood that they would be put to death, assuming that they were arrested and tried and convicted. And researchers have pointed out a lot of flaws in that logic and this issue about execution risk and how researchers try to capture potential perpetrators' perceptions of risk is one of the main issues that the National Research Council highlighted. And this was a report in 2012 about kind of summarizing the research on death penalty and deterrence and critically evaluating it to eventually make the determination that it's very inconclusive and the research is not informative as to whether or not the death penalty actually would deter homicide. But taking a step back, when the question of the constitutionality of capital punishment was brought to the Supreme Court in 1976 after there was the moratorium, and this was in Gregg versus Georgia, one of the arguments that Robert Bork, as Solicitor General, made was that the death penalty served as a deterrent. And I was, in preparation for this, I was reading the New York Times article from 1976. And one of the direct quotes from Bork was, "There's some criminals that can't be deterred any other way." And one of the studies that Bork cited found a deterrent effect attributable to the death penalty, but that finding didn't hold up in replication studies that modified the time period that was being analyzed and has been subject to other critiques. And you don't really see the deterrence argument necessarily in the Supreme Court's opinion reinstating the death penalty, but I don't think it's out of the question that it may have factored into their decision. Also in that New York Times article was mention of, at the time, large increases in homicide. And one of the justices commented during oral arguments that it's obvious, his quote was, "It's obvious from these figures we need some way to deter." And the last thing I'll say, I don't want to keep rambling on, but last thing I want to mention with deterrence is that as a whole, it's not an inherently flawed approach for addressing some crime. And that's not to suggest that, a strong carceral response is necessary or preferred as a means to prevent crime, but strictly from an effectiveness standpoint in specific circumstances, like addressing some violent crime involving youth or gangs, researchers have found that focused deterrence is associated with reductions in firearm violence. And focused deterrence is an approach that involves law enforcement communicating their strategy and the available enforcement mechanisms for punishment to groups of individuals who are known to be involved in gangs or violence. And so the obvious difference here is that between that type of focused deterrence and the potential deterrent effect that people think the death penalty might generate is that focused deterrence is a much more targeted approach that doesn't involve killing as a form of punishment and relies more on the certainty principle of deterrence rather than severity. I'll be quiet now and let anyone else jump in if they'd like to.
Okay, just one quick question that you brought up, the National Research Council 2012 report, which I found to be incredibly well done. Did they bring up some of the flawed studies that did they debunk some of those flawed studies showing a deterrent effect earlier?
Yeah, and in part they did. One of the main things in that report was just kind of outlining these strong assumptions that were made in these other studies, and that just by changing the how we're thinking about execution risk and perpetrators' perceptions of that, you can go from the death penalty having a deterrent effect to actually having that brutalization effect, where now you're seeing an increase in homicide rates. And so it's a well done, very comprehensive report about a lot of the flaws of the research that purported to find death penalty deterrent effects.
Right. Which you tried to address in your study. Miriam, you were going to say something?
Yeah, I wanted, and I so appreciate the research Stephen has done on this issue, just to chime in with a couple of things. And first of all, I also very much, Phil, want to thank you and your colleagues at Death Penalty Focus for setting the stage for such an important dialogue, and thank the nearly 100 individuals who have joined us to listen into this, because this is such an important moment in time in our country where, I really think that we'll be charting the future for who we are and what we stand for. And I think when we start to contemplate where we come out on the death penalty in that context, I think we also have to bear in mind that when it comes to the issue of deterrence and even the message it sends more generally about embracing a death penalty, that, as some have said, embracing the death penalty often says more about us than it does about those who have committed the crimes that we're seeking to hold them accountable for. That when we embrace something that devalues life, and when we embrace something that really epitomizes, as hopefully we'll talk about later, the essence of a broken system of justice, that we are starting to erode trust in the system, and we're starting to corrupt the very meaning of the sanctity of life. And so those sorts of messages, I think, are really ones that devalue life and that send the absolute wrong message. But as Stephen's work has so aptly identified, I think one can call into question generally the notion of whether deterrence even works generally in the context of the criminal legal system. But in particular, when we think about the specific kinds of criminal activity that lead to the imposition of the death penalty, those are the kinds of crimes, often crimes in the heat of the moment, crimes that involve loss of life, crimes that involve extreme conduct or behavior that we are least likely to be able to deter. Those are not the kinds of activities where people are stopping and engaging in a long and calculated decision-making process around the costs and benefits and implications of their actions. And so, I think it's not surprising that research like Stephen's and others tells us that those countries, those states that have moved away from the death penalty have not seen any adverse impact. The sky has not fallen. We have not seen an uptick in murders and homicides in those jurisdictions where they have moved away, where they've rejected the death penalty. And I think the other element that I would also just quickly add is that, as Stephen referenced, that the kind of response that is often most effective is a response that is swift and predictable. And the death penalty is anything but that. We know that when we look at the application of the death penalty, it often takes decades before we reach the actual implementation of that sentence. And it is as arbitrary as any kind of punishment we have seen applied and implemented in our country. And so that lack of swiftness and that arbitrariness, in addition to the nature of the kind of conduct that triggers it, all of those things are critical factors that, not surprisingly, undermine any kind of conclusion or suggestion that it would deter criminal behavior.
Right. And Shelan, anything to add, or should we go on?
Well, I would just to highlight, and then thank you so much, Phil, for having me. And I feel so honored and privileged to be a part of this panel speaking about this topic. But just to highlight some of Stephen's data about the cities that he studied, as part of his study in deterrence, and that the homicide rates did not go down in those areas. So I think it speaks to the validity of the fact that the death penalty does not serve as a deterrent. And we can see that actually here in LA County as well, when you look at the fact that, the governor has imposed a moratorium here in California, and then specifically our DA is not seeking the death penalty here. And for the first time in a very long time, our homicide rates have plummeted. I mean, homicide rates in LA County are significantly down, more so than they have been in the last 10 years. And so you can see it at a local level and even at a state level with the trends of, going down. And even though Stephen hasn't, I don't think, done a study in LA in the last 4 years, his theory is playing out in real time as we're looking at current stats as well.
Great. Yeah, and just to point out that one of the first things I did about 12 years ago when I started working heavily on the death penalty was read Arthur Kessler's marvelous work, Reflections on Hanging. He talked about then, in 1957, how in the preceding 70 or 80 years, no country that stopped the death penalty ever saw an increase in the murder rate. So it's something that goes back more than a century, that all the evidence points in the way that all three of you have been describing. Okay, Stephen, in your study, which we've talked about several times already, you found no evidence of a deterrent effect attributable to death penalty statutes. And your study was based on effects of death penalty moratoriums on homicide rates in Illinois, New Jersey, Washington State, and Pennsylvania. And you found that these moratoriums resulted in a non-significant homicide reduction in all 4 states. Will you talk a little bit more about that lack of correlation?
Yeah, and I previously mentioned, some of the conflicting findings in the death penalty literature about deterrence, with like these minor changes in how the researchers were conducting the analysis, leading to these, varying effects. And I also mentioned that in the National Research Council's report, they criticized these strong assumptions that have to be made for this deterrent effect to kind of play out. And so I wanted to take a different approach to see if changes in death penalty policy would lead to changes in homicide rates. Specifically, if a state moving away from the death penalty would lead to an increase in homicide rates, which is what you would expect if there was some sort of deterrent effect associated with having a death penalty policy. And so to figure out if a policy has an effect, we can't only look at the before and after. So like when Illinois implemented the moratorium in 2000, we can't just look at, a few years before 2000, a few years after to figure out, was there any sort of effect here? Because if homicide was increasing going into that policy change and then increasing after, we don't have good evidence about whether or not that homicide increased more or less than it would have if there wasn't a moratorium in place. So as a comparison for these states that adopted moratoriums, I won't get into the weeds here, but I used a data-driven approach to come up with combinations of these states that, using the ones that kept their death penalty policies in place, to model what would have happened in the moratorium states had they not adopted death penalty moratoriums. And so they're called synthetic controls, and it's essentially you're matching the homicide trends in moratorium state with the synthetic control that you've constructed using all of the other states that kept their death penalties. And when you do that, you also match on a bunch of different characteristics so that, you want to see important factors across the treated and the control states having similarities. So like in law enforcement, per capita, in other forms of crime, population density, other factors that would give us some credibility to what you're doing and make it kind of strengthen your argument that this is the comparison for the moratorium state. And having constructed those synthetic controls, there was no evidence of increases in homicide following the moratoriums, which is to say that having a death penalty policy didn't serve as a sort of deterrent for homicide in those states.
Okay.
If that makes sense.
Yes, absolutely. And by the way, that synthetic control is something we don't use in drug studies. I've never heard of it before, but it's a very innovative way to approach the problem. We have real controls in drug studies.
I was going to make the point that you have randomized controlled trials you can rely on, and that's not the case for us social science folks.
Right. Okay. Shelan, what Stephen found in those 4 states also is consistent, and you've kind of alluded to this already, with data from here in California. 3 counties with some of the highest death sentencing rates in California, Alameda, San Bernardino, Los Angeles, also rank in the top 10 counties with the highest murder rates. And the 3 counties that are in the lowest of sending people to death row, Marin, Placer, and San Luis Obispo, have the lowest homicide rates. So Shelan, you're a special counsel in the Los Angeles DA's office who works closely with George Gascon. And I'm sure the lack of correlation between death sentences and lower crime rates is something you're well aware of, which must make you even more frustrated that those facts don't seem to resonate with the voters who oppose Gascon's stance on the death penalty. Could you comment on that?
Yes, I mean, it is very frustrating, as I alluded to, the myth that the death penalty serves as a deterrent is often used as part of, campaign slogans that are joined with fear mongering and, the use of predator language to, make people so scared that they believe that the death penalty is the right choice. And what we know is that it isn't the right choice for many reasons that Miriam and Stephen have already alluded to, but also because it doesn't give closure to victims, right? As Miriam mentioned, some of the cases that we're reviewing now post-conviction happened 30 years ago, right? And we are continuing to re-traumatize victims with appeal processes and lack of closure, which ultimately, don't, and in a state of California where we have a moratorium, will not result right now, at least, in the actual execution. And there's studies that are also shown that even after an execution, where victims felt like that would bring some closure, that doesn't actually bring the closure or the type of closure that they feel that they would get, that they felt that they would have gotten at the time that they thought the execution was the right avenue to go. So it is very frustrating. And I will just say, I would just like to talk, because in California, I think it's very important to connect what the Racial Justice Act, which was enacted in 2020, is bringing to this conversation, which is also very frustrating. You have two counties right now, LA and Alameda, where judges are finding that there are violations of the Racial Justice Act that contributed to someone being sentenced to death. In Alameda, you have a court order where the judge has asked that every single death penalty case be looked into, because racially charged language and biases were used in jury selection for every one of those cases. And in LA, there's been a per se finding by a judge that comparing defendants to a Bengal tiger is a violation of the Racial Justice Act. And those were the kinds of analogies that were used in penalty to really convince jurors to sentence individuals to death. So we're seeing now that not only does the death penalty not have a deterrent effect, but also there was a lot of racial bias that was used to obtain these death sentences. And so it really makes you question the tactics that were used that were really quite offensive racially, and shows you the racial disparity and the lengths to which individuals would go to create a system that is, in California, we know from the studies that it is disproportionately affecting men of color. That's who is on death row right now. And when you combine two counties that have now had court findings of racial bias used in obtaining those convictions, that it is very frustrating that people still believe that the death penalty is the appropriate way to go about redressing harm.
Yeah. Any other comments? Okay, again, Shelan, what can organizations like ours, like Death Penalty Focus, many of which are 501c3 nonprofits, which means they can't lobby individuals or causes, what can we do to support your ideas?
Well, I think several things. I mean, one, having webinars like this and bringing people like Miriam and Stephen, to settings where people can hear these studies and the effects really nationwide of the death penalty. And I also think creating platforms, social media platforms, other platforms where the other side is being told, the other perspective. Because oftentimes, if it's just connected to a DA, for example, who doesn't believe in the death penalty, it's like, oh, that's George Gascon saying that. But there really is another side to this story that I think individuals can use their platforms to really elevate the time that we're in right now, which is really, as Miriam said, a very critical time that we're in. And I think the use of op-eds to talk about, like Marcellus Williams is a great example of where a very strong op-eds should be written, nationwide about, the risks of executing innocent people that come with the implementation of the death penalty. So I think really your voice, your organization, the use of social media, the use of webinars like this, and op-eds are all great ways, I think, to address and partnering, I think, with other organizations who are like-minded to call attention to this issue is also very important.
Okay, one more for Shelan. You've done a lot of work on resentencing issues. When I talk to non-experts about this, they often say, well, somebody on death row is resentenced, it has to be to life in prison without parole. But I always point out that someone on death row who is resentenced to a long prison sentence with the possibility of parole, that in no way guarantees that they're going to be paroled. If the parole board thinks they're still a danger, after several decades, they can deny the parole, right? Am I wrong to think that way?
No, you're absolutely right. And the parole board, even in California, if you look at, there's, I believe, 21 commissioners who sit on the CDCR parole board, all of whom are very, their resumes are very big. A lot of them have law enforcement and or correctional experience. And those are the folks that are sitting, on the parole board making decisions about parole. And the individual who's going to parole really has to show a number of factors, not just rehabilitation, but, talk through their crime, talk through their background, have accountability. The parole board looks at many facets of that during that hearing. And I have sat through some of those parole board hearings, and people think that they're just in and out and easy. And no, a lot of them are, hours long, and they're very, very intense questions that go, are posed to them by really law enforcement, former law enforcement individuals. So it's not easy, and it is not guaranteed that just because you get a parole date, that you will be paroled on that date.
Okay, good. Miriam, you previously served for 15 years as a federal prosecutor, both in Los Angeles and on an organized crime and narcotics task force in the Mid-Atlantic region. And you are a founder and former executive director of Fair and Just Prosecution, an organization you led for nearly 8 years. So you have been in a unique position of being a prosecutor who early on knew that extreme sentencing was counterproductive to public safety, especially in capital cases. And you publicly stated, quote, "Elected prosecutors have an obligation to pursue justice, and yet the injustices of capital punishment are clear. It's long past time to end the death penalty once and for all." But you didn't end there. You proceeded to enlist 65 elected prosecutors from around the country to commit not to seek the death penalty against individuals with intellectual disabilities and to try to resentence those who are wrongly convicted. Tell us about the evolution of that effect and your efforts to reform the prosecutorial system.
Yeah, thanks for that, Phil, because I think as your question notes, we've really started to find ourselves in a new normal when it comes to the field of prosecution. When I prosecuted in the 80s and 90s, and a little bit beyond that, that was the heyday of the tough on crime mindset. This illusory presumption that we now know was a deeply failed presumption that we could somehow punish our way out of all of societal ills, that we could, lock away and lock ourselves out of individuals who are struggling with poverty or mental health challenges or substance use issues, and that somehow churning people through our prisons and jails was going to address those underlying societal challenges. And I think what we saw was more and more as our criminal justice system grew, it occupied a space that squeezed out social services and mental health supports and substance use treatment, that we let those systems off the hook. And those failed practices, the disaster, the cost, both in terms of fiscal money that was wasted and spent, and the cost in terms of lives that were lost and communities that were decimated as we started incarcerating our way into generations of families that were being broken up, communities that were being devastated. I think that started to become crystal clear, and it led to a growing desire to look for leaders who are going to fill these critical offices of local elected prosecutors, the place where the justice system and carceral carceral policies are really founded and driven, because the vast majority of people who are behind bars are there because of local elected prosecutors, not because of federal crimes, which was the world that I lived in. I think as we increasingly saw the failures of those practices, individuals started to run on an agenda and to win on an agenda of being smarter about what we were doing, of being willing to look at evidence like the sorts of things that Stephen and his colleagues have propounded, of looking outside our borders and learning from other countries who just don't do things the way this nation does, and looking to strategies that would promote healthier and safer communities, but also that would address the kind of systemic inequities and racial disparities that Shelan referenced, looking for strategies that would stop wasting lives and wasting money, looking for strategies that could start to be more humane in terms of the justice system we embraced. And I think that has led over the last number of years to the election of a new generation of elected DAs. You know, people like the DA that we have here in Los Angeles, people like DAs that we see in red states and blue states, in urban areas and rural communities, in the two coasts, LA and New York, and frankly, everywhere in between, who are coming into office because communities are recognizing the tremendous clout that DAs have and their ability both to do damage and also to change the system. And I think we're also seeing, in answering one of the questions that was put into the chat by one of the listeners, a growing recognition that we can't and we shouldn't be measuring their success by conviction rates. We should be measuring success by whether they're leaving our communities better off, whether we are engaging in practices that are removing from the community those that need to be removed for the amount of time they need to be removed, and otherwise addressing societal challenges in ways that are more effective, that are cheaper, that are more humane, and that keep us all safer.
Absolutely. And you bring up the cost issue, which, a lot of people have misconceptions about deterrence. A lot of people that aren't involved in the death penalty at all have misconceptions about that. I mean, the average person just thinks, well, it must cost more. Life in prison must cost more than the death penalty. And it's quite the opposite, I'm told. So, Miriam, how could you get that many prosecutors to publicly state their support? So when you got all of them together and got them to publicly state their support for resentencing those wrongly convicted, it's a risky stance, as we've seen in San Francisco with Chesa Bodine, and in Alameda County with Pamela Price, and facing a recall, and George Gascon defeating one recall, but now he's facing a pro-death penalty prosecutor, as Shelan mentioned, in the November election.
So
how did you get all the prosecutors to do this?
So I think it's really a testament to the fact that they take seriously the essence of their job, which is to serve as ministers of justice, to do right by the community and by all of the individuals who come into contact with the criminal legal system. And I think that increasingly we're seeing leaders in those jobs who have seen a number of deep concerns with the death penalty. You know, they've seen and they've recognized that our country is an international outlier, that we are really one of the only Western democracies that continues to use the death penalty, and that increasingly the trend, not simply internationally, but even in our own country, is away from the death penalty. We now find ourselves in a moment of time where many nations have rejected the use of the death penalty, and around half of our states have either abolished it or put it into a moratorium through leadership in that state. They also increasingly have seen the data that wonderful groups that have worked on exonerations have put out, which tell us that mistakes happen, that innocent people have been subjected to the death penalty, and that we've executed people who have been factually innocent of the crime that they were committed of. We know that there are now, as the data tells us, close to 200 individuals on death row who have been exonerated. We know that, as Shelan indicated, that the death penalty and its use and application is riddled with racial disparities, that individuals are far more likely to be put to death based on their race. We know, as you referenced, Phil, that this is an incredibly costly system, that every death penalty case costs around $1 million, and that our scarce resources can be used in much wiser ways than going through decades of litigation that give no closure to victims and families and simply put them through endless torture in terms of the lack of finality we give them as we seek to implement the death penalty. And they also know, as research like Stevens has shown, that the death penalty just doesn't work, that it's just not making our communities safer. So I think when you put all of those together, it's not surprising that dozens of elected prosecutors have come together to say they won't seek the death penalty. They're advocating for its abolition, and they're revisiting and seeking to commute past sentences. And whether it's because of moral concerns with the death penalty, some of them have simply said that they don't want to be part of a system that sanctions the taking of somebody's life, or whether it's because they recognize how broken and failed this system is, and that we simply haven't been able to fix it, and to presume it can be fixed is the absolute wrong and illusory starting point, or whether it's because of the cost that it results in and the damage that it does to our system as well as those who are part of it. We are seeing prosecutors coming together who are saying enough is enough. They will not be part of seeking to perpetuate this system of a machinery of death.
Right. Well, you bring up the innocence or the exoneration issue. As you said, 200 people have now been exonerated and released from death row. This is, maybe one of you can explain this to me. It's always been a mystery. This is one of the many mysteries. It's always been a mystery to me that it seems to me that after the first maybe 4 or 5 exonerations, people would have said, hey, this thing is, we could be executing innocent people, and it would, if it were a rational decision, it seems like it would have only taken a few exonerations for people to realize this was a terrible idea. Does any of you have an idea why this hasn't gained traction? Why that the innocence thing hasn't been enough? Or is there an answer to that? Maybe it's a mystery.
I don't have a great answer, but I will say in Illinois, that was kind of the driving factor for the moratorium in 2000, is that leading up to it, between the time that the death penalty had been reinstated in 76 and then when the moratorium was announced, there were more people in Illinois who were exonerated than who had been executed. So
Right.
it actually, I think it was Governor George Ryan at the time, but that was one of the things that he cited in his decision, was just that the lack of confidence from the beginning of that these were actually people who were committing homicide. That was just something that they weren't confident enough in to continue with the death penalty.
And he was a Republican, right?
I believe so.
Yeah, I think so. Okay. Any other comments from anybody else? Well, I'm going to ask this question. Go ahead, please.
Sure, Phil, the other comment I'd make is kind of in some ways, a little bit of a sorry statement on where we are in terms of the state of the law. I mean, we know that we now find ourselves at a time where, given recent Supreme Court jurisprudence, even the fact that somebody might be factually innocent, according to some of the recent decisions from our U.S. Supreme Court, has not been deemed to be sufficient to take another look at that death sentence. So, I think some of the hurdles we face stem from the fact that people simply don't know that, there has been this prevalence of innocent people, who have been sitting on death row. I think some of it comes from the fact that it's easy to vilify the conduct and the individual and not look at the actual facts. And I think some of it comes from the fact that we now find ourselves in a moment of time where the highest court in our land has unfortunately determined that procedural hurdles matter more than the potential to be putting to death someone who could well be factually innocent.
Yeah. Well, and apropos to what you just said, Miriam, is a question I hope all of you will weigh in on. And And I think, Shelan, you already mentioned Marcellus Williams, I believe. And so he was executed, a tragic execution. Even when a prosecutor attempts to do the right thing and admit there is a strong possibility of innocence, there are governors who are all too eager to execute, and you've all alluded to this before, and ignore the prosecutor and refuse to grant clemency. How is this happening? And since it seems to be an effective way to undermine prosecutors who are attempting to do the right thing, what can be done about this? What can we do? Anybody? Well, Miriam first, and then anybody else.
Yeah, and I'm sure Shelan has views on it. Sadly, the tragic result in the Williams case isn't the only example that we have of this. The Williams case obviously was outrageous. Physical evidence that had been called into question by the chief prosecutor himself, the coming together of the prosecutor and the victim's family around a joint agreement that the death sentence should not result in the case. And yet, the individual was put to death. We are dealing with that same scenario in other states. We are seeing, soon the Supreme Court will be deciding the Glossip case, where similarly, we have a coming together of the prosecutor and others around the view that the case is just too riddled with a lack of integrity for a death sentence to result. And yet we have individuals at a state level who are seeking to defend that death sentence. And soon the Supreme Court will be hearing argument where a former Democratic Solicitor General, Seth Williams, will be arguing on the same side as Paul Clement, a former Republican Solicitor General, both of whom agree that a death sentence is a miscarriage of justice. But yet, I think probably all of us are in agreement that that is not the outcome we're going to see in the case. Just as in Tennessee and Pennsylvania and other states, we see state officials trying to erode the discretion of local elected prosecutors put into that job by their local community to revisit past unjust death sentences. And, I think sadly, this is all a reflection of a willingness and an attempt to erode what local communities are asking, which is a system of justice that comports with their vision of justice, and individuals at state levels or on higher courts that are trying to push against that tide and undermine that vision of justice that communities want and that they've put in office. And so, I think, again, I would welcome Shelan and Stephen's thoughts on this, but, I think simply being aware of what's going on and calling it out as fundamentally undemocratic, as something that is taking away the right of a local community to decide what they want their justice system to look like and who they want to lead their justice system when they put that local DA in office. I think that those are the sorts of things that we need to be coming together and calling out, and also recognizing, and I know we may talk about this later, that, we find ourselves at a time where the implementation of the death penalty is anything but putting to death the worst of the worst. This is a system that is very much focused on those who are most vulnerable, those who are most damaged, those who are most struggling. When we look at the fact that, 1 in every 5 people on death row has been determined to have serious mental illness. Many of them are dealing with disabilities. Many of them have suffered from past trauma. So this is a system that is not what our communities want, and that is not achieving its objective of purportedly putting to death those who are in fact the worst of the worst.
All right. Shelan?
I agree with everything that Miriam said, obviously. I do think that, tomorrow, to her point, tomorrow is Mr. Glossop's case is before the Supreme Court. This is, I can't impress the issue of a prosecutor, an attorney general, everybody agreeing that this conviction is flawed and that there is an innocent person on death row who is facing, execution. I think that there should be a push for more states to abolish the death penalty. Delaware did it last week. They've joined the ranks of abolishing the death penalty. And then also asking our governors to commute their folks on death row. I mean, we're asking our governor to do that now, given the Marcellus Williams case, given the potential of the Glossip case, and knowing that in California and in LA County, we know this from a case that we exonerated, last year, the Maurice Hastings case, where he was asking for the DNA in his case to be tested for 2 administrations, and he was facing the death penalty, and only because the penalty there was they couldn't decide penalty, was he given a sentence of life without the possibility of parole. He was told that the death penalty, the DNA couldn't be found. Our administration found the DNA, we tested it, and it didn't come back to him. And he is a living example of evolution with science. His conviction was 30 years ago. DNA has come a long way. There are things that are happening and evolutions that are happening that can point to innocence. And I think anytime that you're risking killing an innocent person, that you should really be evaluating what we're doing as a society, as humanity, taking innocent people's lives. That's what we're risking here. That's what happened to Mr. Williams. That's what's happened to Mr. Hastings. It's possibly what can happen to Mr. Glossop tomorrow. So we're talking about 3 people in the span of a month that you're seeing. This is not a penalty that works. And I do think that when politics comes to play in the death penalty, that's when you see people trying to erode the prosecutor's purview and power, when they come in and say, hey, yeah, we've reviewed this with all of the evolutions in science, and with the, looking through all the evidence, and we see that this conviction wouldn't stand. And there are judges and governors who decide, no, that's not enough. We're going to take your power away, and unseating prosecutors who want to do that, right? And really, to Miriam's point, what are we doing? The prosecutors are elected, they run on platforms, and people elect them to execute those platforms. And then individuals who don't agree with what the electorate has voted in is now coming in and saying, this isn't going to work. So whose justice are we looking at when we're looking at the death penalty, right? And I don't think that executing innocent people is ever the answer to the type of punishment that we want to be implementing as a nation and as a society.
Anything to add, Stephen, or you agree completely with them?
Nothing much to add. I guess just from my standpoint, it really seems like a failure of the legal, or I guess judicial system, to not be able to adjust isn't the right word, but in these types of situations where both the prosecutors and the defense and all parties involved are kind of in agreement on something that's not taken into account, and things are still moving forward. So just an observation from a non-lawyer here.
Right. And by the way, just really quickly, and then I'm going to turn it over to Mary Kate to see if she has any questions that have come up. But you mentioned the Glossop case. That's one case where I did read some of the scientific evidence, and it was simply unbelievable. The Supreme Court used an expert who I would have given an F to in my first year pharmacology classes. It was absolutely atrocious. And they decided not to listen to 16 of the most highly qualified pharmacologists in the country. So you got one person who basically didn't know anything about the topic. They took that and they turned down what the 16 qualified experts said. So when I saw that, I couldn't believe that the Supreme Court would actually do something. None of you were probably surprised to see that. But anyway, that's my little 2 cents worth on the Supreme Court and science. Mary Kate, are there any questions that you want to?
Actually, can you hear me, Steve or Phil? Can you hear me? Oh, good. I don't, but I did want to mention one thing to you. all, and that is, we were talking just about, Shelan made reference to the several people who have been executed so far this month. I want to just mention Robert Robertson in Texas, who is, time is really running out on his case on shaken baby syndrome, which of course we all know is junk science. And I just wanted to ask our registrants to go to the either to the Texas Coalition Against the Death Penalty website or to the Innocence Project website, where there are petitions to sign to protest the possible execution of Robert Robertson, because this is another terrible travesty of justice. And that's it. Okay.
And this is scheduled, I think, for a little over a week from now.
Exactly.
And actually, I did have one, maybe we can sneak in one last point that you could respond to. This quote came from the Innocence Project on the impending execution of Robert Robertson. And quote, last week, 34 renowned scientists and doctors, a bipartisan group of 86 Texas lawmakers, faith leaders, innocence advocacy groups, former judges, and former lead detective Brian Wharton, and more other people filed letters in support of Robert Robertson's clemency petition to the Texas Board of Pardons and Paroles and to Governor Abbott. So I don't know how optimistic any of you are that will have any impact. Are you even slightly optimistic, any of you?
Yeah, I would say, Phil, if we follow the trend line, sadly, there's not a lot of reason for optimism here. And I think in answering another one of the questions I saw in the Q&A and tying it, Phil, to something you said, two patterns that we see repeatedly in these cases where I think we all could agree that a just devastating and heart-wrenching injustice has occurred. Two patterns we see are often prosecutorial misconduct and junk science being relied upon as a basis, junk or debunked science being relied upon. And yet there is still a willingness to move forward with putting these individuals to death. And, I think I would come back to what I thought were some, very apt words that were in an LA Times, a recent LA Times editorial on the death penalty, which in my mind kind of reinforced something I said at the outset, which is when we use the death penalty under any circumstance, and certainly when we continue to insist on it in situations where procedural flaws or other hurdles allow us to embrace the view that somebody who may be innocent should be put to death, it says more about us than about what the crime suggests or the individual we are putting to death. The LA Times said, even when we kill the guilty, we become needlessly cruel. But when we kill the conceivably innocent, we become a mockery of ourselves and our supposed allegiance to justice. And I think they said it quite well.
That was a wonderful editorial. Yes. Well, Miriam, Shelan, Stephen, I just love having people like you on. I learned so much from people like you, and you are my heroes in this death penalty fight. So thank you again very much.